Harvey Weinstein wins the appeal. So is he going to be free? The 72-year-old movie mogul was back in a Manhattan court today, his first appearance since the New York rape case was overturned last Thursday. But they are planning to try him again. He'd been sentenced to 23 years in prison after being convicted in 2020 for forcing oral sex on a production assistant in 2006 and rape in the third degree on an aspiring actress in 2013. The appeals court overturned his sentence. Why? Because he didn't do it? No. It was about how the trial was conducted, that the judge allowed jurors to see and hear too much evidence not directly related to what Weinstein was charged with. Now, the California case has different state evidence rules in terms of what's allowed in. So what does this mean for the two cases? Harvey Weinstein's defense attorney is the OAO one and only Arthur Aidala, who joins us now. We're also joined by former sex crimes prosecutor Matt Murphy. Aidala is so important that he's sitting where I usually sit on my set. Arthur, thank you very much. What do you believe this means? You're only handling the New York case, right? Not the LA one?
Correct, but I'm very much in touch, and she was in court today, Jennifer Bogine, who's handling the appeal out in California. And the reason why we're hopeful about the appeal out in California, even though what you said is correct, there is different rules of evidence regarding that type of evidence, that propensity evidence coming in. At the trial in LA, the jurors were made aware that Mr. Weinstein was a convicted felon, that Mr. Weinstein had been convicted of crimes in New York, and that's no longer the case. And I mean, there are a lot of other evidentiary rulings, or the prejudicial value versus the probative value, that were already up on appeal. But you throw in there now that jurors heard that, oh, by the way, the guy you're judging has already been convicted of doing it before. I think that calls for a new trial in LA.
Do you believe that you have a better chance the second time around in New York when the facts themselves haven't changed?
But Chris, I hate to correct you, but the facts...
No, you don't.
No, I do. The facts have actually changed tremendously. In the first case, he was charged with a complaining witness named Annabella Sciorra. She was an actress. He was charged with rape in the first degree, mandatory life in prison count. He was found fully acquitted of those two counts. So that's off the table. Jessica Mann, who you mentioned, he was charged with rape in the first degree. The jury came back and said not guilty. So with Jessica Mann, he's only facing rape in the third degree, of which he's already done the maximum amount of time in jail. So even if we went to trial on that count alone and he was convicted, he still walks out the back door with the rest of us. It's really the Mimi Haley count, which is the sexual assault count, is really the one that he could still stand trial for.
Point taken and appreciated. Brother Murphy, how do you see it?
Well, he wouldn't exactly walk out the back door with the rest of us, right, Arthur? He still faces 16 years in California, if I'm not mistaken. So this is actually a really interesting issue, Chris. In California, we have what's called 1108 evidence. And as a former sexual assault prosecutor, we used to use that all the time, which essentially is prior bad act evidence, which is what basically the judge allowed in New York. But there's no statute in the state of New York that allows him to do that. So among other problems in that case, in the New York case, they reversed it for that. It's not coming back in California based on the inadmissible admission of those same prior bad acts. So this is actually a really interesting thing. I predict that if he is acquitted on this, and I bet Arthur might agree with me on this, I think the New York legislature is going to take a hard look at possibly passing legislation making New York law more like California law.
But that wouldn't affect Weinstein.
No, it would not affect him. But here's another thing, is that if it does come back, even if it is reversed in California, it ain't coming back on the 1108 evidence, which means all of these women theoretically would be fair game to testify in a second LA case. But I think we're a long way from seeing that happen.
Well, Chris, let me just tell you why, if I may.
Arthur.
The reason why I'm going to disagree about having that kind of evidence, that propensity evidence as a law here in New York, is of the 4 women, he was only charged with 3, Chris, the judge allowed 4 other women to come in and say, it happened to me too, me too, me too. Only one of them was put to the test, Lauren Young. She went to trial in LA, and guess what the verdict was? Not guilty. So that's the point. You can't be convicted on rumors. You can't be convicted on women who've never gone to the grand jury. You know what? If they really were complainants, Let him go to the police, let him go to a detective, let him file charges, let him go to the grand jury, let him be indicted on it. Don't let them just pop up out of nowhere without going through the whole process and say, oh, I'm going to walk in the day of trial and say, oh yeah, he's a bad guy. He did it to me too.
Arthur Aidala, I appreciate you coming in. We're going to be following this every step of the way. You have an open invitation. Matt Murphy, thank you very much for helping shape our perspective on what the issues are here. Appreciate you both.
Chris.
Thank you very, very much.
Hey, thank you for watching. Please go to newsnationnow.com, newsnationnow.com, and you can find News Nation on your television provider. And don't forget to click the red subscribe button down below. Then you will get more of News Nation's fact-driven coverage.